Good evening and welcome back to The Particulars. Everything you're about to hear was fact-checked and verified as of 5:30 p.m. Eastern this afternoon. We are investigators teaching from the public record, so it is our opinion, our analysis, not legal advice. Tonight, we catch the Lindsay Clancy trial at a hinge point. So there was no court today. The jury comes back on Monday. And by every indication, the Commonwealth is about to rest and hand the case to the defense. So this is the night we stop and ask, after 3 weeks and a lot of witnesses, what has the state actually shown and what has it not?
We've also got a second Clancy thread most people haven't connected. 2 civil lawsuits running in the background. Plus, a look ahead to the Tupac murder trial in Las Vegas. And a hard one out of Kansas. Let's get into the particulars.
So, standard housekeeping. We do have our, which we don't know how to say.
Let's just say coffee. That's
From now on,
it's
coffee. We're going to call it coffee. If that's wrong, don't come at us. We've done back and forth for 18 episodes. We're going with coffee. And we do have our sticker mule. And I will say, because everyone in our house has insomnia, last night I was up until about 3 o'clock in the morning doing merch boards.
Yeah, they look good too.
So there's a possibility, my friends, that we're going to drop some fantastic merch as soon as I can get my ducks in a row.
Yeah.
And I probably am going to do it not in the middle of the night. I'm going to try, but when I can't sleep, I make merch. So, and then we do have TikTok where you are at right now. All of our replays are on YouTube. And we would love if you subscribe, follow, share, like on all platforms.
Yes, please.
So, without further ado, my friends, let's hop into Trial Watch. So on January 24th of 2023 in Duxbury, Massachusetts, 3 children, 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan Clancy were killed inside their home. Their mother, Lindsay Clancy, a labor and delivery nurse, was found beneath a second-story window with severe injuries. She survived, paralyzed from, again, depending on which version you're going with, from the waist down. We've heard sternum down. We'll leave it at that.
Clancy is charged with 3 counts of murder. She has pleaded not guilty. Her defense does not dispute that she has caused her children's death. It argues she was in the grip of postpartum psychosis and is not criminally responsible. Okay, so the definition we want to give you, the nolle prosequi, the prosecution's formal decision not to pursue a charge. On July 8th, 2026, the Commonwealth entered nolle prosequi on 3 strangulation counts. Clancy now stands trial on the 3 murder counts only.
So there is one thing I want to do really quick when we're talking about age, and it matters because we like to say details matter. So Callan's age, from my understanding, I don't want to say it's a disagreement, but he was 7 months and turned 8 months while he was in the hospital. So that's why there's a little bit of, but I will say that all of the coverage that I have watched in the trial, they refer to him as 8 months old. So that is why we say 8 months. So we're going to get into how the Commonwealth has built its case, which is the order that it is shaping up throughout the days.
So watch the sequence. The state opened with Patrick Clancy and the January 24 timeline. Then scene and first responders. Then the hospital and evidence collection. Then the crime lab and toxicology. Then the medical examiners on cause of death. Then, and this is the move, her own treating mental health providers. And they closed the case in chief on digital forensics, her phone, and a household computer.
That treating provider block is the tell. Prosecutors usually don't call the defendant's own clinicians. Here, they did, to get ahead of the insanity defense. The defense noticed lack of criminal responsibility back in December of 2024. So the state spent days having the people who actually treated Lindsay say what they saw: depression, anxiety, sleep loss, passive suicidal thoughts, but no psychosis, no mania, and no disclosed plan to harm the children. So the gap the treaters leave and the bridge the defense needs. There's actual structural hole in that hand, and it's the hole every criminal responsibility case has. So scheduled appointments don't capture the moment of the offense. Her doctors can say she wasn't flooredly psychotic in an office visit 3 weeks earlier. They weren't in the house on January 24th. So the defense's whole problem becomes, how do you prove a psychotic break at the exact moment it mattered, when even her own providers didn't witness one?
And that's where the window comes in. A near lethal jump immediately after the killings is the single best piece of contemporaneous evidence of catastrophic mental state. Evidence from the moment itself, not a prior appointment.
So we're going to rewind back to day 8, actually the end of the day, the motion that most people missed. So at the end of day 8, the jury was excused. The defense argued a motion filed that very same morning, which was permission to call a set of medical witnesses. So Reddington's framing that these doctors are only reviewing the state's own records, so the Commonwealth needs no time to prepare for cross. It turned into a Rule 14 fight, and Judge Sullivan took it under advisement. So we are going to give you Rule 14. So Massachusetts Criminal Discovery Rule. The reciprocal duty to disclose experts and their basis in advance. It got triggered here because the defense noticed a criminal responsibility defense, which opens reciprocal expert disclosure.
Here's the piece the courtroom didn't see live, but the docket resolves. The judge allowed it by written decision and order the next day. And it ties to an earlier ruling back on July 20th. The Commonwealth had won a motion to exclude the defense's undisclosed experts, but Sullivan said the defense could revisit at trial. This day 8 motion is that revisit. And this time the defense won the door back open.
So here's the read that I will own. This is my analysis. It is not a fact, but the state has been framing the window jump as something less than a genuine lethal attempt. Again, my opinion as watching the full days. Because if it wasn't serious, her behavior looks more calculated. So the defense wants these medical witnesses to prove exactly how serious it was, the spinal injury, the paralysis, because a truly lethal attempt corroborates a woman in genuine collapse, not one staging anything. Both sides spent day 8 fighting over the on-ramp to that bridge. So people don't spend that kind of capital on a side issue.
All right, the Sanders ruling, same judge and why we flagged it 6 days ago.
You sound so defeated.
I hate this case. I've already talked about it.
Well, you're going to keep talking about it.
Bad reality TV. On August 6th, the Massachusetts Supreme Judicial Court, the highest court in the state, unanimously ordered a new trial for Latasha Sanders, a Brockton mother who killed her 2 young sons in 2018, and, like Lindsay Clancy, argued she was not criminally responsible. The court found the trial judge committed prejudice error by excluding her post-arrest psychiatric hospital records, the medical foundation of her defense.
Okay, so here's the detail that matters. That case was tried before William Sullivan, so same judge, same Plymouth County District Attorney's Office, same kind of defense with mental illness and criminal responsibility at its center. So the judge who was just reversed for how he handled psychiatric evidence in Sanders is the judge presiding over Lindsay Clancy right now. And I will say that we talked about this, I believe it was episode 15, right? Is that
one of them?
We talked about it.
In multiple episodes.
And again, it points back to this case even more, because I think some of the decisions where he's taking so many things under advisement and being more cautious, I think it's because he's had a very similar case like this already that is being retrialed. So the McCall standard, Massachusetts test for criminal responsibility from Commonwealth v. McCall, a person is not criminally responsible if, as a result of mental disease or defect, she lacks substantial capacity either to appreciate the criminality or wrongfulness of her conduct, or to conform her conduct to the requirements of the law. So the Sanders opinion restates it word for word, and it is the exact standard that the Clancy jury will apply. So now connect it to the day 8 fight we just walked through. That motion was about this exact category: what psychiatric records and expert opinions the defense gets in front of the jury and on what basis. So Sanders is the SJC telling every trial judge in the Commonwealth you cannot strip a criminal responsibility defense of its medical foundation and still call it a fair trial. So Sullivan just lived that reversal, so it's reasonable to read him as being very careful right now about excluding defense psychiatric evidence. That posture may be part of why the day 8 motion went the defense's way.
Say this the way we did in episode 15. Clearly, this does not mean Lindsay Clancy gets a new trial, and it does not mean the same error happened in her case. Sanders is a different case, a different record, a completely different trial on appeal. It tells us about the legal standard and the judge's posture, not about Clancy's verdict. Do not let anyone run past that line, us included.
And I will say this once plainly, then move on. We connected Sanders to this trial on August 7th with the actual slip opinion in hand. The judge named, the guardrails drawn. We're not here to be first, we're here to be right, and to put the document on the screen so you can see it too. That's the whole job.
All right, days 12, 13, where we actually are. Day 12 was the medical examiner's cause and mechanism of death, and it was brutal. Lindsay broke down. The judge excused the jury at points. Day 13 pivoted to digital forensics, her phone, and a household Surface Pro. Court's dark today. Jurors return Monday, when the prosecution is expected to rest.
So what the evidence does and does not prove, this is where the defense's cross did its most interesting work. So watch what they're building. On the household Surface Pro, the state showed a browsing path from August of 2022, ending on a suicide methods page. On cross, Reddington had the analyst confirm two things: that computer belonged to Patrick Clancy, and Lindsay was at a doctor's appointment for her son when that search happened at the home.
And the analyst acknowledged what every honest digital examiner has to acknowledge. He can see what the device did, not who was sitting at it. A search on a shared household computer doesn't establish who ran it. That's not a technicality, that's the ceiling on what this kind of evidence can prove.
So then the pattern repeats. Prosecutors flagged the children's photos as modified the night before, which sounds sinister until Cross established the modification was a standard iPhone function, turning a live photo into a still, excuse me, and the defense pointed to searches the state skipped. Hallucinations on January 19th, intrusive on January 20th, the searches that cut towards psychosis. So here's my honest read of the shape forming, offered as our analysis, nothing more. Watch what the defense is doing across this whole case. No usable prints on the bands or the knife, DNA on shared household items the whole family handled, a suicide method search on the husband's computer while Lindsay was out, scary sounding data points that soften the second you cross-examine them. The defense keeps saying it isn't contesting the killing, and yet piece by piece on cross, it is showing you how much of the state's she planned this story rests on evidence that can't quite carry it. It's not someone else did it. That's reasonable doubt about premeditation and awareness, which is the whole ballgame in a criminal responsibility case.
Reddington himself is very good, making the state's own witness concede the limits of the state's own evidence in the state's own case. That's a veteran trial lawyer picking his moments. You can credit the craft without claiming to know his endgame.
So precision that keeps us honest, the burden never shifts, but in this trial, the act is conceded. So Lindsay stipulated forensic facts in open court, and Reddington said they are not contesting the government's case in chief. So we do not say flatly they haven't proven what she did or didn't do. We strip away concession and ask what the physical evidence independently proves about premeditation and state of mind. And that is thinner than the headline. So the forensic gap exists partly because the defense chose to concede the act and fight on mental state.
The Surface Pro belonged to Patrick, and the defense raised that he could have made some searches. We report that strictly as the defense's cross and the analyst's concession. In their words, We do not build a Casewalker theory that nudges towards Patrick. He is a father who lost 3 children. The device attribution limit is the story. His name is a fact inside the defense's argument, nothing more. So now where the prosecution is heading. One more read for what's coming. The state has not called its retained forensic psychiatrists. They're still on the list. That's the tell that they can rest soon on the treaters and hold their experts for rebuttal to answer the defense's psychiatrists after they testify.
Remember the structural squeeze, so the defense asked to bifurcate, so to split the guilt phase from the criminal responsibility phase, and he lost that twice. So the same jury weighs the autopsy evidence and the postpartum psychosis defense together, having already seen the worst of it. That ruling is a quiet disadvantage for the defense, and it's why the window jump has to do double duty. Humanize her and prove psychosis all at the same time. So with that, we will push on.
Segment 2, the legal minute, the 2 Clancy civil suits. Running alongside the criminal trial are 2 civil medical malpractice lawsuits in Norfolk Superior Court, both arising from Lindsay Clancy's mental health care. In one, Lindsay Clancy is the plaintiff. In the other, Patrick Clancy, individually and as representative of the children's estates, is the plaintiff. Both name overlapping clinicians who treated Lindsay.
So here's the connective tissue to what we just covered. Several of those civil defendants, the treating clinicians, are the same people the Commonwealth called as witnesses in the criminal trial. The same doctors in 2 courthouses for 2 very different purposes. So we're going to give you a definition, and it is the Medical Malpractice Tribunal. And that is GLC 231-60B. So a Massachusetts screening panel, which is a judge, a physician, and an attorney, that reviews the plaintiff's order or offer of proof early on to decide whether it raises a legitimate question of liability or is merely an unfortunate medical result. One has already been requested in these cases. So this is where we're going to be extremely cautious because a civil complaint is an unproven allegation, not a finding of liability and not a fact. So everything in a civil complaint is an allegation until it is proven. It is separate from the criminal trial.
Yes.
On that note.
All right, segment 3, look ahead. Nevada versus Dwayne Keffe D. Davis.
Almost 30 years after Tupac Shakur was shot on the Las Vegas Strip on September 7th, 1996, the first and only person charged in his killing is on trial. Dwayne Keffe D. Davis, 63, faces 1 count of first-degree murder with a deadly weapon with intent to promote a criminal gang. A jury of 12 plus 4 alternates has been seated. Opening statements will begin on Monday.
Prosecutors are not arguing Davis pulled the trigger. Their theory is that he orchestrated the shooting and supplied the gun. The evidence leans heavily on Davis's own words, his 2019 memoir, and years of interviews, which the judge has ruled admissible. That means he's ruled it allowed to be in as evidence. The state has said it will not seek the death penalty. Now we're going to define conspiracy and aiding and abetting because that's been brought up in the trial so far. 2 theories that can make a person just as legally responsible for a crime as the person who committed it, even if they never fired a shot. A former Clark County DA has named both as the state's likely path here. So they've named that conspiracy and aiding and abetting is the likely path that the
Could be
the state's likely path that they're going to take. The strategic wrinkle a former DA flagged: if Davis doesn't testify, the jury won't learn during the guilt phase that he's a convicted felon. If he does, that opens the door. And the case famously has no living eyewitnesses in the car but Davis himself. So his account is both the evidence and the battleground.
So our take is that this is the rare case where the defendant is effectively the prosecution's star witness against himself. through a book he now says was fiction. We'll be watching Monday for how the defense tries to turn "I made it up to sell copies" into reasonable doubt. So who is ready for tonight's red flag?
Red flag, Winfield, Kansas.
And we will, as we always say, this is one of those things that is very heartbreaking to discuss. However,
yeah, my demeanor of how I present this, do not take that in any way of how I feel about it. I am just trying to state facts that we drum up through the docket and through the record.
Well, go ahead.
On the morning of August 11th, 2026, in Winfield, Kansas, police received a 911 call from a man who said he had killed his family and intended to kill himself. Officers heard a single gunshot as they arrived, set a perimeter, and entered nearly 2 hours later. Inside, they found 6 people dead.
5 victims are identified: Kelly L. George, 44, and 4 children: Carol Williams, 9, Ronald Williams Jr., 7, Sarah Williams, 5, and Kelly McGee Williams, 3. The Kansas Bureau of Investigation says the suspect, Ronald Williams Sr., 53, killed the 5 before calling 911 and then died of a self-inflicted gunshot wound. So we titled this segment Red Flag because there is a documented pattern here, and it is not hindsight. According to reporting on Canvas court records, Williams Sr. had a long criminal history and was a registered sex offender convicted in 1998 of attempted indecent liberties with a child.
The 5 people who died are the story. Keep the focus there. The suspect's record is context for the red flag pattern, not lurid detail. We are going to cover what we talked about tonight. We had the trial watch in segment 1.
That's really small.
The Lindsay
so you can
Clancy trial. We had the legal minute where we talked about the 2 civil suits with the Clancys. And we had a look ahead instead of evidence of the night, a look ahead to the Tupac murder trial, and our red flag where we covered the patterns we see in Winfield, Kansas here just recently with the family that was killed. So that's where the particulars stand tonight. If this is your first time here, we teach from the public record. We tell you what's confirmed and what isn't. And we never pretend a headline is a fact.
If this work matters to you, do 2 things. Follow us here on TikTok and please subscribe on YouTube. Both, so you never miss a night. And if you want to support the show directly, you'll find us on Coffee, Sticker Mule, and our links are in our link tree. With that, our opinion,
our analysis,
not legal advice.
Headlines in,
the details will begin. We'll see you Monday night at 9. Have a great weekend, everybody.